प्रियने विठलांगने कर्णकुंडल धारणे शरणु सिद्धि विनायका तनय मूर्ति शरणु मूषिक वाहना शरणु सिद्धि विनायका. Seated in readiness to this endowment of KSLU country. For this, I will Roshmita Shetty, KSLU Law School, dignitaries and also welcome the cabinet. It gives to the late Mr. Justice R.G. Desai Endowment Lecture. I take this opportunity to welcome the chief guest, Professor Dr. Dilip Uke, Honorable Vice Chancellor, Maharashtra National Law University, Mumbai. Professor Dr. Dilip Uke is the Vice Chancellor of Maharashtra National Law University, Mumbai. Before joining MNLU Mumbai, he served as the Pro Vice Chancellor and briefly as the Acting Vice Chancellor of SRTM University, Nanded, Maharashtra. He was appointed as a Visiting Research Fellow by New South Wales University, Sydney, Australia, and also awarded UGC Fellowship to visit France. He has been a member of various committees of universities, UGC, public service commissions, including the Judges Selection Panel. In 2019, he was conferred the Best Academician Award by the Indian National Bar Association, New Delhi. He is an erudite expert in jurisprudence, constitutional law, and administrative law, and his work in these fields is recognized in national and international forums. On behalf of Karnataka State Law University, I welcome you, sir. I also welcome our guest of honor, Shri Anurag Katarki sir, barrister and advocate, Mumbai. Anurag M. Katarki is an experienced barrister at law called to the bar by the Honorable Society of Grace in London and an advocate practicing in the Bombay High Court and the Supreme Court of India as well as various tribunals. He holds an undergraduate law degree from the University of Warwick, United Kingdom, and BPTC from City University of London. His practice covers a diverse range of litigation, including white-collar crimes, commercial arbitration, and company law disputes. Sir has worked as an associate at AZP and Partners and has been associated with senior counsel Mr. Mukhopadhyay. He provides legal counsel to startups and Fortune 500 companies across sectors such as fintech, FMCG, agriculture drones, STEM toys, marine EV, edtech, and gaming and gambling. His expertise includes contract negotiation, risk management, regulatory compliance, and legal strategy for corporate and commercial law. Sir's chambers, based in Mumbai and Delhi, focus on delivering practical legal solutions for real estate, infrastructure projects, and corporate transactions. He is also involved in legal education, having spoken at webinars on topics like arbitration and foreign legal education. And he has also delivered lectures such as on the India's startup law regime at Bangalore University. Additionally, Sir has commented on high-profile cases such as the legal implications of the Adani Group's US indictment under the Foreign Corrupt Practices Act, as noted in media outlets. On behalf of Karnataka State Law University, I welcome you, sir. I also extend a warm welcome to the president of this program, Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, Hubli. I welcome you, sir. I also welcome Professor Dr. Ratna R. Bharankauder, Dean and Registrar Evaluation, Karnataka State Law University, and the Director, KSLU's Law School, Hubli. I welcome you, ma'am. Lastly, I heartily welcome all the distinguished invitees, faculty members, respected members of RG Desai and Katarki family, members of the electronic and print media, and all the students. I deem it a privilege to present the brief profile of late Honorable Mr. Justice R.G. Desai, in whose remembrance every year this endowment lecture is held. Justice R.G. Desai was born on 1st January 1927 in the prominent family of the erstwhile Bijapur district, then in Bombay Presidency. He graduated from Karnataka College, Dharwad in 1948 and obtained the degree in law from ILS College, Pune in 1950. He started his practice as a lawyer in the district court in Bijapur. He was so recognized for his hard work, his intelligence, and above all, his integrity. In 1958, at a young age, he was appointed as the district public prosecutor of the Bijapur district. He worked tirelessly and conducted the sessions trials with great distinction. His uprightness earned appreciation from one and all in the profession. In 1965, Sir was selected as the district and sessions judge. He served at Dharwad, Ballari, Gulbarga, Mangalore, and Bangalore. In 1978, he was appointed as the Secretary to Government in the Department of Law, Government of Karnataka. In 1979, he was elevated as the Judge of the High Court of Karnataka. On retirement in 1989, Sir served as the Chairman of the State Consumer Commission for 3 years. He also functioned as the State Vigilance Commissioner from 1981 to 1984 as a sitting judge, and he was also known for his drive against corruption in Public Works Department. He married in 1952 to Mrs. Kamla, the daughter of Shankar Gowda Patil of Udupadi, who was a well-known landlord. The couple has 2 sons and 4 daughters who are all well settled. Mr. Arun Desai, who is a practicing lawyer in Bangalore, and Mr. Venkatesh Desai, who is an engineer settled in the US. Daughters are Mrs. Pushpa, married to Mr. Prakash Hosmani, a prominent consulting chemical engineer, Mrs. Uma, married to businessman Mr. Chandrakant Halgali, Dr. Shaila, married to orthopedic surgeon Dr. Basavraj, and Mrs. Vijaya, married to Mr. Mohan Katarki, practicing advocate of the Supreme Court. With this brief profile, I conclude. Thank you. Thank you, Roshita. I now request the dignitaries to kindly pay a floral tribute to the portrait of late Mr. Justice R.G. Desai. Thank you, dignitaries. I now take the honor of inviting our esteemed chief guest, Professor Dr. Dilip Uke, Honorable Vice Chancellor of Maharashtra National Law University, to kindly address the gathering. Please, sir.
This one, front legs, front, front, back. Yes, yes, yes. They are going back. Going this. First slowly. No media. Actually, it's not. So it is going on the live on the mobile. So that it's something going on. Okay. And this one is there too. Forward. One sir.
Otherwise, they will also operate. You can go on instructing also.
Okay. It's all right because they should be able to see. Professor C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, and my dear friend, Advocate Anurag Katarki, Professor Ratna, Dean, School of Law, KSLU, all the faculty members, and dear student friends, a very happy and good morning to all of you. It is a matter of privilege and honor to be here before all of you to speak about the endowment lecture instituted in the name of late Shri Justice R.J. Desai. His contribution in the legal field, which is being acknowledged and remembered by instituting an endowment hearing. I thank Professor Basavaraju, Vice Chancellor, for inviting me, giving me an opportunity to interact with you on the theme, on the topic of amendment and the doctrine of basic structure. It is absolutely fascinating to see that girls are outnumbering boys. I did say so probably even last time when I spoke about constitutionalism and transformative constitutionalism in another hall. And this is the gift when we talk about the women empowerment. This is the gift of the 75 years old, I won't say old, 75 years before when Constitution was implemented. As 75 years have been passed, it withstood the pressures, it withstood the challenges, it withstood the difficulties, even sometimes an attack or attacks on its. As the comparative was saying that change is inevitable. What is permanent in this universe, not only the world, what is permanent in this universe is the change. Since change is the permanent thing, in view of this, it is necessary that what is the Constitution? What is the main object of the Constitution? Main aim of the Constitution? Of course, primarily to establish the state, government, organs of the government, their functions to be assigned, to discharge the functions, the powers are to be conferred, having conferred the powers, limitations upon the powers are to be stipulated, and then yes, rights, moral fundamental rights are to be given to people as well as the enforcing machinery. In view of this, as a noted jurist, Hevosius, a social contractarian, who has said, before that, I must add a disclaimer that there will be little typo errors as well as maybe some grammatical error in these slides. So please forget about those things, ignore about those things. But when he was talking about the constitution, when he was talking about the social contract theory as a part and parcel of natural law theory, he said that social contract is an actual fact of human history. I quote, social contract is an actual fact of human history and the constitution of every state has been preceded by the social contract. That's what we could see, we the people of India. Constitution of every state has been preceded by the social contract and the people, the constitution, depending upon the social, economic, political and other conditions existing at that particular point of time in that particular society. And look at this, it is not there. Several things will come up which may not be there because of the paucity of time. Look at this, depending upon the social, economic, political, we can add regional, religious, cultural, so on and so forth conditions prevailing, existing, then at that particular point of time in that society. And we understand that those social, economic, or all other conditions undergo the change. That's why the time is not static, as it says. It changes. As time changes, demands, wants, desires, all those things also undergo change. Because constitution is the supreme law of the land. It organizes the societal life of the people of that particular country across the world wherever the constitutions are there. And that's why the life of the nation, that is not static. It is dynamic. Since life of the nation itself is dynamic, constitution has to be dynamic. Constitution cannot afford to be a static one, a rigid one. It is also to be dynamic. And that's why we call it as a living document, organic document. Organic, why? Because it deals with the relationship not only with the people and the state, the horizontal as well as vertical both, people and the state as well as people amongst themselves. So this relationship is itself a dynamic relationship which needs certain changes with the changing circumstances or the conditions, maybe social, economic, political, cultural, religious, regional, so on and so forth. That's why living document, it is the living document, it is the organic document, wherein with the change in political social conditions, it also has to undergo the change. That's what has been said, that the constitution which has been drafted, which has been enacted in one period, in one era, in one context, it cannot be an adequate one, it will not be found as an adequate one, sufficient one in different era or different period. And that's why it is necessary to effect the changes, it is necessary to effect certain amendments, and therefore for that the constitution also must contain some mechanisms, some machinery to effect those changes. When these changes are required to be effected, when the changes are required to be made, the modes may be different one, maybe informal one. Those who have studied the constitution, they must have been aware about Article 368 of the Indian Constitution, no doubt. But that is the formal method, formal mode of amendment of the constitution. The mode may be informal as well. Next. Informal mode of amendment, in a way, in a sense, that without amending the constitution, without amending the provisions of the constitution, without resorting to the power and the procedure prescribed by the constitution of whichever the country, still the effect or the provisions of the constitutions undergo the change. That's what, for example, in case of United States, fundamental rights are provided. When fundamental rights are provided, it will come rather the first 10 amendments, which is known as quote unquote Bill of Rights. Fundamental rights are provided, but unlike India, as we have also fundamental rights provided under the Constitution, but at the same time, we know well there are grounds of reasonable restrictions also provided, coupled with those fundamental rights. Article 19(1) A, B, C, D, like, and then 2, 3, 4, 5, 6. Everywhere. Whereas in case of the United States, only fundamental rights are provided, but there are no limitations, there are no restrictions. The absolute right theory has been otherwise absolutely rejected by the judiciary everywhere. No right, including any fundamental right, can be an absolute one. No one can claim the right, right to privacy, though guaranteed by the Constitution by Puttaswamy. It is not an absolute one. That right to privacy would be at private place. Even in private place also, that right to privacy cannot be an absolute one. It is always coupled with certain reasonable restriction. And that's why in the United States, though the rights are provided under the constitutions, in absence of any specific express limitations, restrictions, the US Supreme Court came out with those limitations, those restrictions. Article 1 of the US Constitution, which provides for freedom of speech and expression. In Sullivan case, New York versus Sullivan, when it was challenged, the restriction was challenged. Curtailment of fundamental right of speech and press, there is no expression. In our Constitution, there is no press, freedom of press, but it is included impliedly under speech and expression. Expression is a wider term. Then, in absence of the limitation restriction provided by the Constitution, US Supreme Court in Sullivan came out with the restriction or the limitation, holding that no fundamental right can be an absolute one. So that is nothing but the kind of the informal amendment of the US Constitution. Similarly, here in India, in J.P. Mittal, much before Maneka Gandhi, Article 217, Clause 3 of the Constitution provides that the determination of the age of a judge of a high court, when President takes that decision, when President decides, the power is conferred upon the President, decides the age of a high court judge whenever there is a dispute, his decision shall be final. However, in the instant case in J.P. Mittal in 67-68, much before Maneka, Indian Supreme Court held that the decision of the President, though is accorded the finality by the express provision under Article 217(3), if the decision of the President is found is based upon irrelevant consideration, extraneous consideration, unreasonable, or under the influence of the executive, despite of such a finality accorded by the express provision of the Constitution, still such decision can be declared as invalid by the court, because the decision is arbitrary, decision is irrational. That is nothing but the informal amendment of Article 217, Clause 3. On one hand, the finality is accorded to the decision of the President. On the other hand, the Supreme Court came out with this implied limitation in the form of unreasonableness, in the form of extraneous consideration. Similarly, Maneka Gandhi, all of us know well, I do not have to speak at length. Even now, at this moment, at this juncture, there is no word due under Article 20. No person shall be deprived from his life and personal liberty except according to procedure established by law. That's all. And Eko Gopalan, when it was challenged that such procedure was unreasonable, it was rejected. Supreme Court held in Gopalan that Article 21 is not similar to the Fifth Amendment of the US Constitution, because the Fifth Amendment of US Constitution also provides the similar right. No person shall be deprived from his life, liberty, and estate without due process of law. It was argued on behalf of Palan that this procedure established by law is similar to, is equivalent to the due process clause of Fifth Amendment of US Constitution. The Supreme Court responded that if you know, under the draft Constitution of India, the word due was there very much. However, it was deleted subsequently because of whatever the reason. Sir B.N. Rao, who met Justice Felix Frankfurter of US Supreme Court and told him happily, sir, we have also incorporated your clause of the Fifth Amendment. He said, don't do that, because that gives so much discretionary power to the judiciary. So clause which was there, the word which was there under the draft constitution was consciously, with deliberations, debate, was deleted. And that's what in Gopalan court said, that the word which was there, which was deleted, how we can read, how we can insert. However, as all of us are aware, that subsequently in Maneka Gandhi, the same Supreme Court, of course, same Supreme Court means not the same judges, under different circumstances, different context, read the word due, even though any procedure established by law, if found, is it as unreasonable, unfair, substantive due process and procedural due process, just, reasonable and fair. Law has to be just, reasonable and fair, and procedure also has to be just, reasonable and fair. Even now, as I said, and all of us know well, that at this moment the word due is not there yet. Yet, still it is to be read, it is to be implemented, it is being implemented since Maneka, and that is nothing but the informal amendment. Parliament did not resort to Article 368 to amend Article 21. Yet, Article 21 stands amended by virtue of the Maneka's decision, inserting the word due therein. That is the mode of an informal amendment. The word which is not there was read under Article 21 by the Supreme Court. In a parallel situation, similar situation, in case of S.R. Bombay versus Union of India, the issue was about the President's power to impose the President rule, in a popular parlance we call it, under Article 356. Even now, Article 356 remains the same textually, that whenever there is a failure of constitutional machinery in the state, whenever there is a failure of constitutional machinery in the state, and the governor of the state submits the report that there is a failure of constitutional machinery in the state, or otherwise means even in absence of a report submitted by the governor. Rather, in Tamil Nadu in 1991, the governor then, Mr. Surjit Singh Parnala, had refused to submit the report to the government president that there is a failure of constitutional machinery in the state. In absence of the report submitted by the governor, still Article 356 was invoked, power was invoked by the president, and the present rule was imposed. That was in 91. Whereas Bombay was decided in 1994, precisely on 12th March 1994, wherein Supreme Court, along with several other things, came out that governor's report that there is a failure of constitutional machinery in the state is mandatory. It is a precondition. Governor must submit the report that there is a failure of constitutional machinery in the state. Without that, President is not, or it is not possible for the President to invoke the power under Article 356. The word, dear friends, otherwise, even still there very much under Article 356. Bombay is also the facet of informal mode of an amendment. See, the two parallels, to contrast. parallel and contrast. In case of Maneka, the word which is not there, the word due which is not there came to be read by the Supreme Court under Article 21. The word otherwise which is there under 356, Supreme Court had refused to read that word under Article 356. In Article 21, word was inserted. Under Article 356, quote unquote. Under Article 356, the word was deleted. The word which is there stands deleted. In Maneka, the word which is not there stands inserted. So both these are the instances of informal mode of amendment of the Constitution without resorting to the power and the procedure prescribed under Article 368 of the Indian Constitution. Similarly, the latest, just 8th April, today is 10 days before, on 8th April, law students must know this. Do read the newspapers at least. The Supreme Court Division Bench, headed by Justice Paradwala, delivered the judgment, a landmark judgment. Under 200 as well as 201 both. The issue was about State of Tamil Nadu versus Governor of Tamil Nadu. Politics of assent. Politics of assent to the bills passed by the legislatures, state legislatures. The government of the different political party passed the bills, submitted for the assent to the governor. You must have been aware, unless it is assented by the governor at state level and by the president at central level, it doesn't become a law. Those bills were returned. Again, the state legislature reiterated those bills, passed those bills as they were without any change. Again, submitted for the assent for the governor. Then the governor, instead of assenting, referred some bills to the president, reserved for the assent of the president under 201, 200 and Article 201. These are the two corresponding provisions. Since 2019, those bills were pending, like a table tennis, one ball from this side, another from that side, it was settling. For your information, Article 72 of the Pakistani Constitution, Pakistan's Constitution, provides that once they call is that their parliament, Pakistan's parliament, called as National Assembly. Within 10 days, president must assent. If doesn't, it deems to be assented. Article 72 of the Pakistan's Constitution. That was quoted by the Supreme Court in its judgment, in this judgment. Wherein Constitution is silent. That within how much time the governor shall accord its assent to the bill. But those constitution silences were made as silent. Those constitutional silences shall be voiced by someone else. And that's how we are living in a era of rule of law. We are living in a democratic country, liberal democratic country. How a constitutional functionary can abuse his power. And that's why the Supreme Court in recent judgment, government of Tamil Nadu versus governor of Tamil Nadu, state of Tamil Nadu versus governor of Tamil Nadu, categorically held that if those bills are not assented, Supreme Court has invoked the power vested in it, Article 142 of the Constitution. Supreme Court has the power of Article 142 that Supreme Court can pass any order in a matter pending before it to do quote unquote complete justice. That is the extraordinary power vested in the hands of the Supreme Court, which was conferred by the Constitution. Supreme Court did not usurp that power that is conferred by the Constitution. And therefore, the power which has been conferred expressly by the Constitution under Article 142, Supreme Court had invoked that power under Article 142 and held that those 10 bills, not 1, 2, 3, those 10 bills are deemed to be assented. Supreme Court granted the assent to those 10 bills on behalf of the government. Not only that, the timeline was also prescribed for the further. Of course, it is a debatable point. This is not the forum, this is not an occasion which demands or which warrants the deliberation about this. That 1 month and 3 months, including even the president. Article 200, 201, they are silent about this. Dear friends, by virtue of the judgment in Tamil Nadu, Article 200, 201 stand amended in an informal, more informal manner. So, the modes are different. Formal mode we know well, but even by way of informal mode, and not only in India, elsewhere as well. US it is there, UK it is there, elsewhere it is there, they are there, and that's why there is nothing unconstitutional. There would be unconstitutional constitutional amendments also. We will come across with this. Hence, in view of this, it is necessary to have this more informal mode. Some, I won't quote, I won't go beyond the prescribed limits which are assigned to me, the playfield which is assigned to me, that someone called this judgment is undemocratic, contrary to the parliamentary democracy, or nuclear, quote unquote. Article 142 is the nuclear missile which destroys the democratic institution, so on and so forth. I won't say who had said so. You read the newspapers, you will come to know. Point is that, is it democratic on the part of the governor? Someone said that judiciary acts as a super executive or super parliament. So, in view of this, it is necessary to have the balanced approach, understanding the need, demands, not only need, demands. Constitution, there are several silences. There are several gaps. Though it is a lengthiest constitution, it doesn't contain each and everything. Where is the power that Chief Justice of India shall be the senior most judge? It is not there at all. It is a convention which has been developed right from the day one, barring one of the other exceptions. So there are several such silences, and those silences shall be voiced by the highest court of the land to do justice, quote unquote, to do complete justice. So these are the implied or informal mode of amendment of the Constitution. As we know, there is a formal method of amendment. Formal method of amendment which is provided under the Constitution of every country. Whether the Constitution, you must have studied when you studied the Constitution, like basic principles of the Constitution, one of the basic principles of Indian Constitution, it is a blend of rigidity and flexibility. Neither it is rigid nor it is flexible. Dr. B.R. Ambedkar, when the issue was deliberated in the Constituent Assembly, then Dr. B.R. Ambedkar, the chairman of the drafting committee, was responding to those deliberations, was responding even to the criticism or the questions, said that, and it will come further also, that any such constitution which is so liberal in the sense, so flexible, then the government of the day, if wants to, desires to implement its certain agenda or the policy, may go on changing. Would that be the constitution? When it finds the difficulties to implement those policies or agenda, it may go on amending the constitution, may go on changing the constitution. It should not happen so. because ultimately Constitution is the suprema lex, highest law of the land. Under that, Parliament was established under the Constitution. Supreme Court was established under the Constitution. Since they are originated from the Constitution, they shall abide by the Constitution which has created these organs, and therefore it is necessary that it shall not be so flexible, it shall not be so elastic to the stretchable or breakable point, wherein amending constant process therein in Britain, because Britain, you must have been aware that there is no such written constitution, it is an unwritten constitution. We call it as a supremacy of the constitution. One of the basic principles of Indian constitution is supremacy of the constitution. Constitution is supreme. Therein in Great Britain, it is supremacy of the parliament or sovereignty of the parliament. Parliamentary sovereignty is one of the basic principles of British constitution. Parliament is so supreme, rather there was an adage that British Parliament is so supreme, it can make a law which might turn man into woman. It is an absolute law-making power, just to depict, just to show. It is an absolute law-making power. Here it is not so. Article 13 imposes the limits. State shall not make any such law which takes away or abridge the rights guaranteed by Part 3. The express limitation is there. Parliament is not supreme in that way. In case of lawmaking, though lawmaking is one of the basic functions, rather is the function of the Parliament. It is not an absolute one. Constitution itself places the limits upon the lawmaking, ordinary lawmaking power. And that's why it is necessary to have the blend, mixture of rigidity and flexibility as such. When we approach further, we'll come to know, and there is a discussion and debate also, as constant power and ordinary lawmaking power, there is a difference. Wherein that process, amending process, is also known as constant process. That process differs from country to country. Just let us take an instance, illustration from the United States. In United States Constitution, it is a rigid constitution, unlike Indian Constitution. It is rigid constitution. Why? Because the process is of two stages. One is initiation and second one is ratification. As we call a parliament, Indian parliament, they call it as a Congress. In the United States, in America, they call it as a Congress. There are two houses, House of Representatives and Senate. As we have Lok Sabha and Rajya Sabha, they are House of Representatives and Senate. So therein, the amendment may be proposed or initiated by 2/3 majority of either of the house, each of the house, both of the houses. By 2/3 majority, that amendment is to be initiated or proposed. Once adopted, then it is to be ratified by 3/4 of the states. 3/4 of the state. Not unlike India, when we come across, it is to 50% here in India. 1/3 procedure which is there. So therefore, the amending process is difficult, and that's why US Constitution is known as the rigid constitution. I will skip this because we already referred to. Then in Canada it was enacted British North America Act. Only British Parliament had the power to amend the Canadian Constitution. Under the British North America Act, which is known as BNA Act, only the British Parliament had a power to amend Canadian Constitution. In 1949, that power was given to Canadian Parliament. I forgot to add subsequently, but still the consent of the Britishers was required, even though power was given, still the consent from the Britishers was required then. However, in 1982, that power was absolutely completely transferred to the Canada. That is the situation in Canada. Similarly, in Australia, like United States, Australia also it is rigid constitution. Amending process is rigid there, difficult there. Same way, it is two stages: initiation and ratification. And then China, ignore the typo error. It is China. In China also, Article 72 of the 1947 Constitution, there is a one particular body called as National Assembly, which function is only to make constitutional amendments, nothing else, not an ordinary legislation like India or like in US Congress. Having seen these informal and formal methods, then I would like to spend some time about the theoretical framework of the amending power as well as the process both. That is something little different for you, little new for you also. Those who have studied jurisprudence must have been aware about the Kelson's pure theory of law. And it is not a ground norm, it is a ground norm, GRUND. Ground norm is the highest norm, which Professor Kelson said is a sui generis. That ground norm doesn't originate from any other norm. All other norms are originated from the ground norm. Let me add at the juncture, those who are really keen about the research, subsequently it will come, but go through Indira Nehru Gandhi judgment. Justice Matthew has discussed Kelson's pure theory of law in that judgment. Vis-a-vis amendment. You realize that. What is the applicability? What is the relevance of Kelson's theory of law, pure theory of law to amendment? So that is, it being the highest norm that he pointed out, either the parliament or the constitution. However, he also has said that one norm must secure the minimum efficacy, minimum effectiveness from the people. On one hand, it is to be sui generis, on the other hand, has to obtain the minimum effectiveness or the minimum efficacy from the people. Because ground norm is the highest one, and therefore only all the norms are, in our common parlance, all the laws are to be emanated, are to be originated. Then, similarly, Professor H.L. Hart, who talked about rules, system, legal system is the system of rules, primary rules and secondary rules. And secondary rules are of three types: adjudication, legislation, and one is rule of recognition. Rule of recognition is an ultimate criterion of validity of all the rules of the legal system. It is an ultimate criterion of validity of the legal system, which recognizes all the rules of the legal system. And thereby, that is also one of the relevant points, either theoretically or jurisprudentially, about the Constitution. Why? Because it is the Constitution wherefrom all the laws enacted by the Parliament or the state legislature shall be in tune with the Constitution. They cannot be, that's what are the ultra-virus to the Constitution. Then subsequently the delegated legislation. Delegated legislation has to be in tune with, has to be in accordance with the as well as the Constitution. That's what are the hierarchy from Kelson's point of view. Hierarchy of norms or hierarchy of laws. And then even sub-delegation, if at all it is there. Sub-delegation, delegated legislation, parent statute, and then the Constitution. That is the hierarchy. Same way, here in two, it is the rule of recognition in case of Professor H.L. Hart. Pandit Nehru, the first Prime Minister of the country, but observed in Constituent Assembly. The Constitution is not only to be solid and permanent, but should permit even the national growth. So it contains both. It shall be permanent and solid, but at the same time it shall permit the national growth. It means that If the national growth is to be achieved, certain changes are required to be effected, certain amendments are required to be effected. Dr. Ambedkar, in the same Constituent Assembly, had pointed out. You can see that. If the government amends the Constitution on every Saturday, why do you have the Constitution? So, neither it shall be rigid, nor it shall be so flexible, so elastic to the breakable point of time. And that's how the Indian Constitution is the blend of rigidity as well as flexibility. So, rigid Constitution like United States or Australia, and I would say the flexible, but the mixture of flexibility and the rigidity like India. And that's why in United States, in last 47 years, how many amendments? Only 27 times. In Australia, in 125 years, only 8 times. And in India, in last 75 years, 106 times. Right or wrong, apart. There were certain, as I said, unconstitutional constitutional amendments too, also, like 42nd Constitutional Amendment Act, 39th Constitutional Amendment Act. Certain scholars of constitutional law across the globe, across the world, before we enter into the domain of amending power as well as the procedure. Herman Feiner, who pointed out that to amend the Constitution is to deconstitute or reconstitute the Constitution. Certain parts which are required to be deleted, certain parts which are required to be added, and that's why he called it as deconstitute or reconstitute. Thomas Jefferson, who pointed out that he was not rather in favor of frequent changes, but must coexist with the advancement of human mind. As time changes, we have said initially itself, as time changes, wants, demands undergo change. Similarly, even the Constitution also undergo the change. When Pierre Garson, who pointed out that a Constitution which doesn't contain provision for its amendment with the development and growth and expansion of the community, that is society, which it is intended to govern, would be most inadequate and imperfect deed of partnership. What is deed of partnership? Recall what you, Mauritius, said. It is a social contract. It is the actual fact of human history. Social contract is an actual fact of human history. And that's why we, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and all those other things which are there. So it is necessary that since people have made the Constitution in one era, in one period, depending upon the needs prevailing, existing at that particular period of time, point of time, after 10 years, after 15 years, or after 20 years or 5 years, those need demands will undergo change. And that's why with the growth of the time, Constitution also undergo the change as such. Now, there is a debate and dichotomy. We call it as a amending power. Constitution now under Article 368 uses the term constituent power. Whereas certain scholars, constitutional law scholars across the globe, across the world, came out with different versions of constituent power and amending power. Whether these powers are both the powers are same, or there is any distinction, there is any difference between these two powers. Wherein CS, who have pointed out that people implement the constituent power and constituted power. Try to understand what he intended. Constituent power, just to make you understand, according to him, constituent power was exercised under Indian circumstances. Again, I would say it is just an illustration for make you understand. Constituent power and constituted power. Constituent power was exercised by the Constituent Assembly when it has made the Indian Constitution. Constituted power is the power vested in the Indian Parliament under Article 368. That is constituted power. Constituent power and constituted power. Constant power when the constitution was made, enacted by a particular body in exercise of constant power, which was delegated to it, which was conferred upon it by the people. I have doubt in the sense, I have some issues about this, just for the sake of or food for your thought, if you wish to. Where from the Constituent Assembly came into existence then? Read further. Constituent Assembly of India came into existence under Independence Act 1947, Section 8, Subsection 1. Section 8, Subsection 1 of the Indian Independence Act 1947, which provided for the constituting the Constituent Assembly to draft the Constitution for India. I don't want to engage in debate or even a discourse at this juncture, because it may appear, it may be found little, somewhat, the stuff somewhat maybe little hot for you. So, Constituent Assembly was provided under Section 8, Clause 1 of Subsection 1 of the Indian Independence Act 1947. Rather, Assembly came into existence because there was a dual role. On one hand, Constituent Assembly, on the other hand, even it was working as a parliament. Some members were the members of the government, and then they become the members of the Constituent Assembly. Some members were the members of Constituent Assembly, they became the members of even the government. Likewise. There were several such. However, you must have been aware, if at all, those who have studied history, political history. Indian Independence Act 1947 was enacted not by the Indian Parliament. Indian Independence Act was enacted by the British Parliament. Apply Kelson there. Apply Kelson there if you want to, if you wish to. But origin is from the British Parliament. It was the British Parliament's enactment. 1947 Independence Act was the enactment of the British Parliament. Does that mean the Indian Constitution? Of course, let me add at the juncture, you may be confused. Don't be confused. Subsequently, that Indian Independence Act was repealed by virtue of Article 395 of the Indian Constitution. When it came, it should have been done. To my understanding, it should have been done. I don't want you to be so much taxed. I don't want your minds to be taxed so much at this juncture. Be lighter. This is a little, that's what I said, maybe complex or complicated for you to grasp or understand at this age or at this point of time. So that's why constant power and the constituted power. That's what he said, the CS said. Once the constitution is framed, once the constitution is enacted, constant power ceases to exist. That is over. Constant power is over. Right or wrong, that apart. We are not engaging in debate or discourse. According to him, once the constitution is enacted, drafted, that constituent power ceases to exist. It is no longer there. It will not be there thereafter. That is over. Exercise of constant power is there. It was there. Now no longer would be there. What remains is the constituted power. And that's what rather we call it as the amending power. And that's why, just for the sake of your understanding, what remains is the constituted power, that is nothing but the amending power. The critic of, will go further, the critic of basic structure doctrine, that is, it is a product of the Supreme Court, it is the product of the judge's mind, judge's philosophy, so on and so forth, which imposes the limitations upon the amending power of the parliament, so on and so forth. If you apply this logic, constant power and constituted power, there were no limitations upon the constant power, but there were limitations upon the constituted power. And that's why basic structure doctrine can be justified on the ground of distinction between constant power and the constituted power. Moreover, whatever the things which could have been said subsequently at this juncture, as a matter of convenience, I would like to highlight that Article 13(2), which imposes the limitations upon the exercise of law-making power of the Parliament, which is an ordinary legislation, when the Constitution imposes the limitations upon the ordinary law-making power of the Parliament, how it can leave amending power in an absolute manner in the hands of the Parliament, which is a higher. Constitutional amendment is the Constitution, becomes the Constitution, is it? Can we say that it is less important? No. It is a part and parcel of the Constitution. Any provision which has been amended is a part and parcel of the Constitution. Being a part and parcel of the Constitution has an equal, similar status of earlier Constitution, as that's what the dichotomy distinction which has been made by Justice Matthew in Indira Nehru Gandhi. Original Constitution and then the amended Constitution. Original Constitution came into existence without any limitations. Original Constitution came into existence without any limitations, whereas amended Constitution comes into existence with the limitations like doctrine of basic structure. Of course, subsequent to Keshwananda, no doubt. So, original Constitution was not subject to any limitations, restrictions. Amended Constitution is subject to limitations or restrictions. And that's what constant power and constituted power. Hence, the other jurist called Schmidt, who pointed out, who observed that constant power originates from the political elite. That's why we, the people of India, like. I would like to skip that. You can read through here from, because it is taking some time. Because when body still remains, then Paces, another scholar who observed that exercise of constant power shall meet three essential conditions. Original or exercise of constant power must meet essentially three conditions. One, as a foundational power of a people, it has to be all-inclusive. Try to understand this. Being a foundational power of a people, it has to be all-inclusive. In a way, separation of powers theory is not applicable to the constant power. Because it is a creation, it is a creator. Constant power is the creator of the Constitution. It being a creator of the Constitution, it being a creator of all the organs, it is to be all inclusive. It can create legislature, it can create judiciary, it can create executive, all the things. So it is to be all inclusive. Constant power is all inclusive. Legislative power can't be, amending power can't be. In a way, in other words, there are no limitations upon the constant power, whereas in case of the, I will use the word for your convenience, amending power, there are limitations. Second one, as an act of self-determination of that people, it has to be a free and voluntary act of individuals. That's what, it is free from all the limitations, unlike the amending power. And last one, that is third one, it has to accept or at least tolerate dissenting votes. Constant assembly debates. When you go through, there were several dissents given clause by clause. If you read constant assembly debates, CAD volumes must have been available in the library, if at all. And go through those. So these are the three essential conditions which are required. Then Justice Matthew, who distinguished between the people as a possessor of the constant power and people who exercise the power. Again, the same thing. As I said, read Indira Nehru Gandhi, you will realize that original Constitution, rather Justice Matthew, it may skip from my mind when I refer to Indira Nehru Gandhi. Just as Matthew, dear friends, and observe in Indira Nehru Gandhi that constitutionality of the constitutional amendment has to be tested on the touchstone of the constitution itself. Constitutionality of the constitutional amendment has to be tested on the touchstone of the constitution itself. Right or wrong, that apart. That's why he had tried to make the distinction between the constant power, the possessor who are possessor of constant power, and those who exercise the power. Then Carl Frederick, constant power is the power to establish the constitution, whereas amending power is to change the constitution which originates from constant power. He also tried to make the distinction between constant power and the amending power. Amending power originates from the constant power. I skip the other jurists. Then Richard Albert, constant power theory has enabled courts to place limits on the amending power in many jurisdictions. He is a present scholar of constitutional law. It is everybody's choice. To my understanding, I like him and the way he presents. What he said, just read, just see. That constant power theory enables the court to place limits on the amending power. Enables courts to place limits on amending power. Read Keshavananda there. Read basic structure doctrine there. What Richard Albert said. Constant power theory enables the courts to place limits upon the amending power. In many jurisdictions, particularly if we talk about India, doctrine of basic structure are nothing but the limitations imposed upon the exercise of amending power by the Parliament under Article 368 hearing. What are those limitations in India? Basic structure doctrine. In Colombia, substitution doctrine. I won't elaborate because of paucity of time. In Turkey, it is a headscarf decision that was also evolved by the judiciary theory as a formal method of amending the constitution is provided under Article 368 of the Constitution. But dear friends, at this juncture, I would like to point out that whatever Article 368 we read today, we see today, was different than what it is there. Till some time we'll come across with that later. It was not the same as it is there today. Today, if you read Article 368, notwithstanding anything in this constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of the constitution in accordance with the procedure described in this article. I added that this provision was amended by 24th Constitutional Amendment Act. Only points which I wanted to highlight, that's why I added here. That is one. Secondly, the clause 2 of Article 368. What is important herein? That an amendment, whatever is there, shall be presented to the President, who shall give his assent. Unlike in case of ordinary legislation, wherein the word is who may give his assent. If Parliament enacts any law, of course, President has to assent, has to give his assent. Who may give his assent. You may remember Gary Jal Singh's veto to Rajiv Gandhi's Postal Office Bill. That's what now Supreme Court said. Justice Paradiwala led bench said there is no such pocket veto existing in India as like United States. So two things were added here. One is constant power, the word constant power, and secondly, President shall give his assent to the bill. In India, the amendments could be carried out by 3 ways. One is simple majority, other one is special majority, that is 2/3, and third one is certain provisions which are there provided under Article 368 itself that shall be passed by 2/3 majority plus ratification by at least 50% of the states as such to this provision. Similarly, clause 3, which was also added, that nothing in Article 13 shall apply to any amendment made under Article 368. Why it was done so, there are reasons, we'll come across with those reasons, and 4 and 5, which are there, we'll refer to them as. Herein, there are several developments took place subsequently. Breadth of power test, direct impact and effect test. As time is running, I will just begin with the decisions in nutshell asked. During the course, we may refer to one or the other things. The first case came up before the Supreme Court was Shankari Prasad versus Indian in the year 1951. The issue therein was that whether the Parliament can amend the Constitution, whether the Parliament can amend fundamental rights, and whether any amendment carried out by the Parliament under Article 368 is a law within the meaning of Article 13 of the Constitution or not. Because Article 13, it is subject to fundamental rights, wherein it was held therein that firstly Parliament has a power to amend the Constitution. Fundamental rights can be amended under Article 368, and amendment is not a law within the meaning of Article 368, Article 13 asks. That was the primary decision. But however, you please keep it in mind that what it said, that Parliament has a power to amend the Constitution, Parliament has a power even to amend fundamental rights, and any constitutional amendment carried out by the Parliament under Article 368 is not the law within the meaning of Article 13. Why? Because under Article 13, state shall not enact any law which abridges, violates fundamental right. And that's why it said it is not the law within the meaning of Article 13. Therefore, it can amend even fundamental right. That was Shankari Prasad. Subsequently, in Sajjan Singh versus Rajasthan, the 17th Constitutional Amendment Act, which was challenged, the decision was delivered by 3 versus 2, wherein Shankari Prasad was reiterated, wherein Shankari Prasad was followed in a way that Supreme Court held hearing also in Sajjan Singh, that Parliament has a power to amend the Constitution under Article 368. Parliament can amend even fundamental rights, and any constitutional amendment passed by the Parliament is not the law within the meaning of Article 13 of the Constitution. If you see these two decisions, Shankari Prasad and Sajjan Singh, what you would realize, if at all you understood, Supreme Court simply said Parliament can amend the Constitution, Parliament can amend fundamental rights. It means, before I refer to dissenting judgments there in Sajjan Singh, it means that there were no limitations. In Shankari Prasad and Sajjan Singh, though Supreme Court held in both the decisions that Parliament can amend the Constitution as well as fundamental rights, that was nothing but quote unquote an absolute amending power of the Constitution given to the Parliament by the Supreme Court. In Shankari Prasad and Sajjan Singh, it was free from any limitations or restrictions. In Sajjan Singh itself, as I said, this is delivered by 3 versus 2. Two dissenting judgments very important. One was delivered by Justice Hidayatullah. Another one was delivered by Justice Mudholkar. Justice Hidayatullah, in his dissenting judgment, he held that fundamental rights are not amendable, are non-amendable, are unamendable because they are fundamental. Whereas Justice Mudholkar, in his dissenting judgment in Sajjan Singh, held that there are certain basic principles of the Constitution which cannot be amended. He had used the term principles. There are certain basic principles of the, he did not elaborate what those principles are. Yet he has said that there are certain basic principles of the constitution which cannot be amended. If you look at these two dissenting judgments, one of Justice Hidayatullah, who said fundamental rights are unamendable, non-amendable. That was nothing but Justice Hidayatullah judgment led to the subsequent judgment in Golaknath. Whereas Justice Budolkar's dissenting judgment, wherein he said there are certain basic principles of the constitution which cannot be amended, led to nothing but the Keshavananda Bharati. We give credit to the doctrine of basic structure or basic feature to the Keshavananda court. It was in Keshavananda Bharati versus State of Kerala, the Indian Supreme Court has evolved the doctrine of basic structure, which has placed certain implied limitations upon the exercise of amending power of the constitution. Real hero, real credit, true credit goes to Justice Budolkar in his dissenting judgment, in previous judgment, that is Sajjan Singh, who said there are certain basic principles of the constitution which cannot be amended. So these were the two decisions which were delivered. These were the two dissenting judgments which were delivered by Justice Hidayatullah and Justice Budolkar in Sajjan Singh, which led to Golaknath decision subsequently, and then Keshavananda Bharati judgment subsequently as such. Similarly, thereafter, after Shankari Prasad and Sajjan Singh, then Golaknath versus State of Punjab, wherein the 11 judges bench was to decide about the constitutionality of the amendment, legality of the amendment. The judgment was delivered by 6 versus 5, wherein both the decisions, Shankari Prasad and Sajjan Singh, were overruled, holding that Parliament doesn't have the power to amend the constitution under Article 368. Parliament doesn't have a power to amend fundamental right under Article 368. Because that time Article 368 was different. That's what I said, pointed out earlier. Even the heading of Article 368, procedure to amend the constitution, that's all. Even clause 1 of Article 368, there was no word power, constant power as it is there, you must have seen now, was there. That's why Supreme Court, by majority hearing in Golaknath versus State of Punjab, the 11 judges bench, the decision was delivered by 6 versus 5. Majority held that Parliament doesn't have the power to amend the constitution under Article 368 because Article 368 merely prescribes the procedure. Simple majority, special majority, and special majority plus consent of 50% of the state, that's all. It doesn't confer the power upon the Parliament to amend the constitution. It merely, Article 368 merely prescribes the procedure. That was the first one in Golaknath. Secondly, rather late by Justice Subbarao, Chief Justice Subbarao, majority held, that fundamental rights are beyond the purview of the amending power of the Parliament. Why? Because they are fundamental, they are sacrosanct, they are immutable, they are natural. Natural opinion was invoked by Justice Subbarao. There. Those who are keenly interested can go through that judgment. They said they are essential. Fundamental rights are essential, without which your human personality cannot be prospered, cannot be developed. That's why they are fundamental. They are not merely legal, they are not merely statutory. And that's why Parliament doesn't have the power to amend fundamental rights. Since the Parliament doesn't have power to amend the constitution, since Parliament doesn't have the power even to fundamental rights. Why? Because according to the majority in Golaknath, amendment carried out by the Parliament under Article 368 is their law within the meaning of Article 30. What is Article 30? State shall not make any such law which takes or abridges your fundamental rights. Constitutional amendment is itself a law within the meaning of Article 13, and hence the state is disempowered. State doesn't have the power. If at all, see the, I won't say the beauty, see the kind of a logical logic or illogical logic. Court majority therein in Golaknath, it has said that since it is a law, constitutional amendment carried out by the Parliament under Article 368 is the law within the meaning of Article 13. Hence, if at all the power to amend Constitution is to be located under Article 248. Article 248, dear friends, is nothing but residuary power. There are three lists under 7th schedule, list 1, list 2, list 3, which are related with the law making power. List 1 central, list 2 state list 3 concurrent. If any of the subjects are not enumerated in all these three lists, that is called as residuary power, for which the Parliament has the power to enact the law. Hence, the Supreme Court majority in Golaknath said that power, if at all, power to amend the Constitution at all is to be located, shall be located only under Article 248, which is the residuary power aspect. So it has created a kind of havoc otherwise. Golaknath's decision has created not only the controversy, Golaknath's decision has created the havoc. The Supreme Court majority also gave a poser. Poser in a sense, it has posed the question. Don't worry about it. It has posed the question, can a parliament in exercise of its amending power wipe out completely the constitution? Can a parliament in exercise of its amending power wipe out, erase the constitution completely? Of course, it has only posed the question, did not reply, did not give any answer. That answer came impliedly subsequently. That's what rather. The kind of the decision by majority which was delivered in Golaknath. Of course, having held that Parliament doesn't have the power to amend the Constitution, having held that Parliament doesn't have the power to amend fundamental rights. Till then, 17 Constitutional Amendments Act were passed, till then fundamental rights were amended. Hence, it has invoked doctrine of prospective overruling. Doctrine of prospective overruling is the doctrine by which the effect of the decision is to be given prospectively from future, not from the past. Otherwise, all those amendments carried out by the Parliament till then would have been nullified by virtue of the Golaknath's majority decision. They were to remain valid forever. Only thing was that thereafter, after the Golaknath decision, Parliament was not supposed to exercise its amending power vis-a-vis fundamental right. As well, amend Constitution under Article 368, it said that that power, if at all to be translocated, is to be located only under Article 248. Because either in the heading of marginal note of 368, there was no word of power, or even in the clause 1 of Article 368, there was no word of constituent power. Hence, Golaknath has created the controversy. Golaknath has thrown several such challenges to the governing the country, and therefore, to overcome all the challenges, to overcome all these difficulties, 24th Constitutional Amendment Act was enacted by the Parliament. While enacting 24th Constitutional Amendment Act, it was the clause 4 under Article 13. Amendment is not a law. Under Article 13, clause 4 was inserted, which says that any constitutional amendment is not a law. Then Article 368 also has a measure of abundant care. Clause 3 was added thereinto. Then in marginal note, Article 368, power, the word power was added, power of the parliament and procedure therefore. Because it was not there. In the heading, in the marginal note of Article 368, the word power was added, power of the parliament and procedure therefore. Similarly, the clause was added, clause 1 was added, you have seen earlier. Clause was added under Article 368 that Parliament in exercise of quote unquote constituent power as abundant caution, not only in the heading, not only in the marginal note, even in the main body of the provision, the word constant power was added. And then President's assent to the amendment has been made obligatory, mandatory, not directory, adding the word shall assent to such constitutional amendment. So these were the changes which were made by 24th Constitutional Amendment Act. Obviously, when these changes were made, when these amendments were made, then it was obviously challenged. In Keshwananda Bharati versus State of Kerala, AR 1973 Supreme Court 1461. Wherein both 24th and 25th Constitutional Amendment Act, they were challenged. Since Balaknath's decision was delivered by 11 judges bench, hence 13 judges bench was required to be constituted to overcome the difficulties posed by Balaknath's decision. Wherein in Keshwananda also, the decision was delivered by 7 versus 6. Rather, I must add at the juncture that otherwise it was equally split 6 versus 6. Since there was a equal decision 6 versus 6, it was only Justice Khanna's concurring judgment tilted the balance in favor of majority, and that's how it became 7 versus 6 instead of 6 versus 6. As obviously it was expected that Supreme Court in case one of the largest ever bench till now held that Parliament it has overruled Balaknath, declared. In case one of the Supreme Court overruled the Balaknath decision, held that Parliament has a power to amend the Constitution under Article 368, because by the time the marginal note as well as clause 1 of Article 368, the word powers were inserted. Parliament has a power under Article 368 to amend the Constitution. Parliament has a power even to amend the fundamental right. However, Parliament doesn't have an absolute power, but it cannot exercise the amending power so as to destroy the basic structure or basic feature of the Constitution. Someone says and argues that during the course of an argument, it was Nani Palkhiwala who has referred to this kind of the notion of basic feature. However, if one researches, one would find out that German Constitution contains the name is German. How to pronounce it is up to you. Don't try now, right now. You can do so later on. Whatever it is there written, it is there written. You can pronounce, you can try, you can make an attempt later on. So German Constitution contains this doctrine. The translation may be basic structure, or translation may be basic feature, whatever you call compevier, or and something else is also there. So therefore it was imported very. Because Constitution is supreme. That's what one of the basic principles of the Indian Constitution we study, supremacy of the Constitution. So supremacy of the Constitution is one of the basic feature. There in Keshwananda, it holding that Parliament has a power to amend the Constitution under Article 368 as per the procedure prescribed by. However, it cannot exercise its amending power so as to destroy the basic structure or basic features of the Constitution. And few elements were pointed out: supremacy of the Constitution, republican and democratic form of government, secular character, separation of powers, judicial review. It was merely illustrative, it was not exhaustive. List of the features as basic, it was merely indicative, not as an exhaustive one. Wherein the same logic was imported that the life of the nation is dynamic. Sorry, life of the nation is dynamic one, and therefore it requires effecting certain changes in the constitution. You may recall, just go back to Golaknath. The question which was posed in Golaknath: can a parliament in exercise of its amending power wipe out the constitution completely? Impliedly, the answer was given in Keshwananda. Parliament, though in exercise of its amending power, can amend the constitution, but it can't exercise the power so as to destroy the basic feature of the constitution. It means that Parliament cannot amend the constitution so as to wipe out the constitution completely. Doctrine of basic structure or doctrine of basic feature is nothing but the doctrine of implied limitations plus stipulated by the Supreme Court here in India. Parliament cannot rewrite the Constitution under Article 368 as or the doctrine of basic structure which was evolved by the Supreme Court in Keshwananda, limiting, stipulating, restricting the amending power of the Constitution. Thereafter, in Keshwananda, the doctrine of basic structure, there was an opportunity before the Supreme Court to test as well as decide upon the applicability of the doctrine in Indira Gandhi versus Raj Narayan, AR 1975, Supreme Court 2299. Here, I just give a brief background of the decision of the case as such. Mrs. Indira Gandhi, who was elected to the Lok Sabha from Raebareli constituency of the Uttar Pradesh as a member of Lok Sabha, became a prime minister, leading the government, whereas her rival, Mr. Raj Narayan, filed an election petition challenging her election to Lok Sabha from Raebareli constituency on the ground of unfair electoral practices under Representations of People's Act 1951. Election petition was filed before the Allahabad High Court. I won't go in all the details. It is a destiny. If you read the book by Prashant Bhushan, The Case Which Shook India, it elaborates all events. Wherein the rival has filed the petition casually. He knew that nothing is going to come, nothing is going to happen. Even lawyers, they knew that nothing is going to happen. And that to file by juniors, young juniors, you prepare and file. That's how matter was filed. Matter which was filed was to be heard by a judge who was rather transferred. First judge was transferred. Second judge fell ill. Third judge was retired. See the destiny, that's what. Otherwise, the kind of the decision was delivered and then the subsequent events would not have occurred. Justice Jagannath Sinha, who decided the judgment, decided the case in Allahabad High Court, was the fourth judge. Not first, not second, not third. He was the fourth judge who summoned the Prime Minister. And the rest is history. He declared Mrs. Indira Gandhi's election to the Lok Sabha from Raebareli constituency as illegally invalid, found guilty, indulging in corrupt electoral practices under Representations of People's Act. Oh my God. First time in the history, Prime Minister's election was declared illegal. Obviously, the government was shaken. Then opposition parties led the marches, criticisms, demonstrations, demanding the resignation of the Prime Minister then from the Prime Ministership, not only from the ministership. Several political agitations were led then, political upheaval. Therefore, then, of course, appeal was filed before the Supreme Court against the judgment of the Allahabad High Court. And then 39 Constitutional Amendment Act was enacted. 39 Constitutional Amendment Act was passed by the Parliament. 39 Constitutional Amendment Act was passed by the Parliament in exercise of its power under Article 368. By virtue of 39 Constitutional Amendment Act, the clause 4 was added under Article 329. By virtue of that, the Prime Minister's election was made immune from judicial challenge. One. That too with retrospective effect. Secondly, power of all the courts, including the Supreme Court, was taken away. It was made immune from any judicial review. Two things. And it has created the havoc. Before that, little politics as it happens. KSLU what was held? That Parliament can exercise the amending power, but it can't exercise so as to destroy basic structure. It means limited amending power. Mrs. Indira Gandhi was the Prime Minister then. She didn't like how you are tying hands of the government to amend the constitution. You are imposing the limitations. She didn't like the majority decisions. That's why when the appointment of Chief Justice of India moment came, general practice convention I pointed out initially also, senior most, not by age, by service, senior most judge is to be appointed and was to be appointed either as the Chief Justice of India. Justice Shillong, Justice Grover and Justice Hegde, three senior judges. The first one, as a matter of constitutional convention, was to be appointed as the Chief Justice of India. Whereas the judgment was delivered by, as you know, 7 versus 6. She didn't like anybody from majority. Because you are holding that Parliament doesn't have the power to amend the constitution in an absolute manner. That's why she surpassed Justice Hegde and she appointed the fourth one was part of dissenting minority judgment in Keshwananda, Justice N. Ray, who held in Keshwananda. Please mark this. Please try to understand. Who held Justice N. Ray held in Keshwananda that Parliament has an absolute power to amend the Constitution. She liked him very much. But this man saying Parliament has an absolute power to amend the Constitution. She appointed him as the Chief Justice of India, the fourth one, because he held Parliament has an absolute power to amend the Constitution, no limitation, no restriction, no basic structure, no basic features. You amend the way you want. She appointed the fourth one in rank as the Chief Justice of India. Of course, as a matter of protest, all the three, Justice Shillong, Justice Grover and Hegde, they resigned from their post. He became automatically the senior most judge. So convention was also followed. Dear friends, when this matter came, appeal from the High Court judgment before the Supreme Court, and then 39 Constitutional Amendment Act, which was enacted, adding clause 4 under Article 329 in making the judiciary obsolete as well as immune Prime Minister's office from the challenge, came up before the court. Double challenge to 39 Constitutional Amendment Act as well as appeal against the Allahabad High Court verdict. Now, Justice Hegde is the Chief Justice of India, who held in Keshwananda in a minority. Parliament has an absolute power to amend the Constitution, no limitations. She was quite sure. He is the Chief Justice, he will take care of that. 39 Constitutional Amendment Act will be constitutionally valid, legally valid. See the gentleman? When matter came before him, he laid out the bench. Justice, including Justice Vali Chandrachud, Justice Matthew, Justice Mukherjee, everybody unanimously declared 39 Constitutional Amendment Act as unconstitutional, as violated to the doctrine of basic structure. person, the judge who held, a difference is only of 2 years, 73 to 75. It was the first decision came up before the Supreme Court to test the legality, applicability, instrumentality, utility of the doctrine of basic structure. How a parliament can exercise a power, rather one of the judge amongst them held that 39 Constitutional Amendment Act is nothing but the bill of attainder. What Parliament did in exercise of Article 368 is not to amend the Constitution, but it has decided the matter pending before the Supreme Court. It is delivered legislative judgment, quote unquote. 39 Constitutional Amendment Act was nothing but legislative judgment delivered by the Parliament in exercise of its power under Article 368, which violates the basic structure of the Constitution. Same judge, even Justice Chandrachud, then said it violates equality, there's no opportunity, it violates principles of natural justice. Because that is the legislative judgment. 39 Constitutional Amendment Act is the legislative judgment. It destroys the essential democratic features where the opportunity was given to the other party to be heard of or to argue, nothing sort. And that's why the kind of decision delivered by the Indira Nehru Gandhi, they are there. Justice Khanna, free and fair election is one of the basic features which has been violated. Justice C.N. Ray, Chief Justice C.N. Ray, the same judge, and rule of law violated. See the transformation of minds of individual judges. Right or wrong, hearing may be right. During at that time, maybe situation warranted, we don't know, we don't want to doubt or question the mindsets. But same person changes his mind after 2 years or so, as such. No. So this was when parliamentary democracy was held. These features went on to be added there because it violated the notion of parliamentary democracy as free and fair election, as Justice Matthew has said. Indira Nehru Gandhi, reigning Justice Matthew particularly, has discussed the Kelson's pure theory of law, original constitution as I pointed out, and the amended constitution, when he has said that, I repeat again, Justice Matthew has said, constitutionality of the constitutional amendment has to be tested on the touchstone of the constitution itself as such. That's why constitution may be silent in some cases. Those constitutional silences shall be voiced, and those constitutional silences shall be voiced as Justice Paradivara did in Tamil Nadu's case. Same way, these judges did. It was a unanimous judgment delivered by the court there. These judges did then in Indira Nehru Gandhi as such. Of course, thereafter, then national emergency was imposed on the 25th June. Then in 1975, 4 days Second Constitutional Amendment Act, that too at not only midnight, I would say morning 3 o'clock was passed. Opposition leaders were arrested. That was the political history. And clause 4 and clause 5, 2 clauses were added under Article 368. Firstly, there shall not be any limitation upon the Parliament's power to amend the Constitution, and any amendment cannot be challenged before any court of law. In other words, basic structure doctrine was completely nullified by virtue of 42nd Constitutional Amendment Act. Clause 4 and 5, these two clauses were added under Article 368, that any amendment carried out by the Parliament cannot be challenged in any court of law. Judicial review was taken out, and there was no limitation, there was to be no limitation upon the amending power of the Parliament. Of course, subsequently, in Minerva Mills versus Union of India, these two clauses, clause 4 and clause 5 of the Article 368, were held as unconstitutional. I will just skip few things because of the time. Only 2 points. Only 2 points I will refer, and then we'll conclude. As you know, 9th schedule, wherever any act, any legislation which has been placed under 9th schedule was to be immune from judicial review. What about the constitutional amendment if it is placed under the 9th schedule, whether it was to be immune from judicial review? Of course, several scholars of constitutional law gave credit to Coil law, which was decided in 2007. It is there mentioned also. However, if we read Vaman Rao, which was decided in 1980 itself, Vaman Rao versus Union of India, then in itself it was observed, pointed out, held rather by the Supreme Court that any constitutional amendment which was placed in the 9th schedule will be otherwise immune from the judicial review, but only till 23rd April 1973. Today is 19th April. Why till 23rd April 1973? Because on 24th April, KSLU Bharati was decided, and because in KSLU Bharati, the doctrine of basic structure was evolved. It means that even if the constitutional amendment is placed under the 9th schedule after 24th April, it will not be immune from judicial review. That could be tested on the angle of the doctrine of basic structure, and if such amendment which was placed under the 9th schedule, if it is found as violated to any of the basic feature, then that can be declared as unconstitutional. So Vaman Rao to Coil law. Coil law have reiterated that any constitutional amendment placed under the 9th schedule would be tested on the touchstone of basic structure doctrine, and it is found as destroying any of the basic features would be declared as unconstitutional. Only protection to any such amendments would be till 24th April, the day on which the case was decided. That is one. Secondly, the doctrine of severability. Article 13, doctrine of severability is that any law which is bad, any part of the law which is bad, whether it can be separated or remaining statute can be saved. That is about the ordinary legislation. Same doctrine was thought of applicability of constitutional amendments. In Kyoto Holohan, not Kimoto, Kyoto Holohan versus Jachillu, the judgment which is in relation to 10th schedule of the Constitution, that is about anti-defection law. Wherein in Kyoto Holohan, para 7 was declared as unconstitutional, whereas remaining part was kept as intact, was declared as constitutional. In a way, the doctrine of severability was made applicable to the even constitutional amendment. And then last point. All of us know well, doctrine of basic structure which was evolved to determine legality or constitutional validity of constitutional amendment. Whether it can be applied to determine the legality of ordinary legislation. Wherein in Ismail Faruqi versus Union of India, the act which was enacted by the Parliament then, acquisition of certain areas at the Act, acquiring the land. Now the Ram Temple has been constructed. Acquisition of certain areas at the Act which was enacted by the Parliament in 1992. And wherein it is an ordinary legislation which was challenged before the Supreme Court in Ismail Faruqi versus Union of India. Section 4, subsection 3 of the Act was held by the Supreme Court as unconstitutional, not on the ground of any material provision, but on the ground of secularism, which is one of the basic features of the Constitution. In a way that Supreme Court applied the doctrine of basic feature even to determine the legality of ordinary legislation. That is, can even the doctrine of basic structure or basic feature be applied for administrative action? Yes, I remember you have referred earlier. Power of the President under Article 356 is the administrative procedure, is the executive power. Power of the governor, not president, power of the governor as well as the president. It is the administrative power. Whereas when after the demolition of then Babri Masjid, four state governments which were dismissed, dissolved, assemblies were dissolved, Uttar Pradesh, Himachal Pradesh, Rajasthan and Madhya Pradesh. All cases were clubbed together and that's how gave rise to the SR Bombay versus Reno of India. Wherein the Supreme Court invoked again the basic feature because they said that was contained in the manifesto, electoral manifesto. So even in case of the exercise of administrative power, purely administrative power, the doctrine of basic feature or basic structure which has been applied by the Supreme Court as such. Dear friends, there are plenty of things to talk about. Lastly, what I would say, it was there rather. You can see last one. Mr. Anurag is carrying the book, Justice Rohingya Nariman, which was published, and he spoke on the doctrine of basic structure recently. What he had said, you can see. There were arguments, counter arguments, whether this is extrajudicial overreach, judicial overreach, this and that. What Justice Nariman had said recently, just few days before, I believe, in the function of his publication of his own book, that if doctrine of basic structure goes out, may God save this country. It means that irrespective of, in spite of certain drawbacks or certain dark spots like Alien Jabalpur versus Shukla, maybe here and there, no doubt. But it is the highest court of the land because of which, imagine, our beloved neighbor, I'm talking about Pakistan. How many years the democracy has survived there? Both are twins, India and Pakistan, they are twins. How many years democracy has survived there? How many years democracy is here, barring the period of emergency? Yet, how it was possible? It became possible because of the strong independent judiciary. Hence, doctrine of basic structure is here to stay, and I fully agree with Justice Rohingya Nariman that if doctrine of basic structure goes here from, may God save the country. Thank you so much for your patience.
Exhaustive.
Because time little.
Thank you, sir. We are truly grateful for your valuable words and the time you have taken out to be with us today. May I now respectfully invite Professor Dr. C. Basavaju, Honorable Vice Chancellor, KSLU, to kindly felicitate our esteemed chief guest as round of applause and respect.
The felicitation is done, no? So I have to sit?
Yes, sir.
Not standing?
This is our formality.
Oh, how are you, sir? I can't. Can I stand?
No,
I'm not used to. Thank you. Thank you.
I will also stand. Yes. One photo. Standing. Without. Okay. Thank you.
Thank you, dignitaries. I now request our guest of honor, Sri Anurag Pataki, barrister and advocate Mumbai, to kindly deliver his address to the gathering. Please.
Good afternoon, everyone. Thank you for having me here. Special word of thanks to Dr. Ratna and Dr. Basavaraju for organizing this, and also to the Karnataka State Law University to invite Dr. UK to deliver such a beautiful speech on the doctrine of basic structure, a topic which is very dear to my late grandfather, who was very fond of Constitution. And I always remember one thing that he always said: as a student of law, in law school you might read 5 subjects, 10 subjects, 12 subjects. Law is ever changing, ever evolving. As rightfully mentioned, that it's not static. It keeps on changing based on the demography, geography, geopolitical issues. As a student of law, you will be a student of law even after being called to the bar. Whenever in doubt, the only thing that you need to always refer back to is the Constitution. The Constitution is where it all began, where all the powers have been dealt in. Whenever in doubt about any new law, always open it up. You know from where that particular organization or that particular government department has gotten the powers from, and that is where you start from. Always begin from the beginning. Now, during the course of this lecture, very interesting points were raised. I actually learned a lot. A few things, coincidentally, yesterday I met Professor Sharma, who is also a professor of law, now retired. He was the guy who was a trade unionist who spearheaded the daily wages case, which I don't know if the students know, but the professors must be knowing. The daily wages case actually directly impacted 75,000 families, and indirectly, what I've been told, has impacted almost 20 lakh people. And that very case has been spearheaded by the legal cell of this very university 30 years ago, actually 40 years ago. It's a very proud moment. And I had a very in-depth conversation with him, and also coincidentally, sir also raised the same topics about the Indian Independence Act and how the British gave that to us. And there is a book that also which he has written called Constitution Unriddled, which, like sir said, the Indian Independence Act was enacted by the British. They made the Constituent Assembly, and this book actually enlightened me about how the Constitution in its present form is quite similar to the Government of India Act 1935. So it's very interesting how we see. We say that the Constitution is made by the people, for the people, but the people were decided by the erstwhile rulers. So it's intriguing to look at that. Sir rightly said that, quoted Mr. Rohington Narman, where he said that if the doctrine of basic structure is not there, God save this country, and we would like to actually thank, as he has also thanked, Dr. Nani Palkiwala, but for whose brilliance the basic structure doctrine would not have become and remained a part of India's constitution jurisprudence. And also the council, H.M. Sirvai, who had the courage to change his mind and wholeheartedly accept the basic structure. Now, this is very important as future lawyers for you to see. Sometimes what happens is that you're so involved in your client's case that you forget that your duty towards the court is actually paramount and even above your duty towards the client. So this is a clear example of how a counsel got his duty towards the court, and he agreed that this is paramount, and he could look at the greater justice and agreed with Nani Palkiwala. even though his clients was completely opposite. Why I'm saying all this is because you are the future of this country. You are going to bear the beacon of justice. This profession is not for the faint-hearted. It requires long hours, late nights, lot of reading, lot of pressure. Maybe sometimes you might feel you're not even rewarded for that pressure because this is an adversarial system. You might have worked the hardest, especially as litigation counsels. You might have worked the hardest. Everything is in your favor. Someday, sometime, that day, maybe that particular point didn't click to you and the case goes away from your hand. It's a very daunting profession, but never lose heart. Keep reading, keep learning. You will always be a student of law. I remember I met Mr. Fali Nariman just before he passed a few months ago, and he said he's still learning at the age of in the age of 93 or 94, I reckon. So you'll always be a student of law. Always remember that Constitution is your Bhagavad Gita. You read that day in and day out, learn, interpret. Don't rely on other people's interpretation. Always learn to interpret yourself. Read the judgments yourself, and always uphold the basic thing that law is always about justice. And if the justice not being given, there will be a reason as to why absolute justice is not given, which will be reading between the lines. Having said that, thank you so much for having me. You all have been an amazing audience, and sir has been an amazing speaker enlightening us with comparative countries' constitution. What I wrote was Colombia, Germany, America, Pakistan. I've been enlightened today. Thank you, sir, for giving such a beautiful lecture. Thank you, everyone, for having this. Thank you.
Thank you, sir. May I now request Professor Dr. C. Basavaraju, Honorable Vice Chancellor, KSLU, to kindly felicitate our esteemed guest of honor, Shri Anurag Kadambi. Thank you, dignitaries. Today is a historic event wherein KSLU is entering into a memorandum of understanding with Maharashtra National Law University Mumbai in order to explore research in the field of law, to encourage exchange program for faculties, and also to promote cultural exchange between these two institutions so as to carve ahead in the field of legal education. I now request Vice Chancellors of both esteemed universities to exchange the memorandum of understanding.
Yes.
Thank you, Dignitaries. At this juncture, I would like to invite Professor Dr. C. Basavaraju, Honorable Vice Chancellor, KSLU, to kindly deliver his presidential remarks. Please, sir.
Good afternoon to one and all. Distinguished guests of today's function, Professor Dr. Dilip Oke, Vice Chancellor of Maharashtra National Law University, Mumbai, and a good friend of mine. We have with us a barrister and advocate, Mumbai, Sri Anurag Katarki, Dean, Registrar Evaluation of Karnataka State Law University, and my colleague, Professor Dr. Ratna Baramgowda. In absentia, Srimati Geeta Kaulgi, Registrar of this university. Distinguished guests who have come over here today, on our invitation, Professor G. V. Patil, Mr. Neil Kere, Dr. Rangaswamy, all my teachers, colleagues, dear students, all invitees, members from media, ladies and gentlemen. Today we don't disturb. When there is a very serious discussion is going on very important constitutional issue, try to understand the nuances of these discourses. We have to go a long way, not only in identification of the constitutional issues, but also for resolving these issues. You are all budding students and going to be the budding lawyers. Understand the intricacies and nuances of the constitutional provisions and the interpretations made by the Supreme Courts and the various high courts. Today I am really moved by the discourse given by Professor Dilip Oke. The way in which he took the issue from the basic structure to the amendment of the Constitution, juxtaposing two important concepts together and making an analysis and appreciation is a very difficult task. But the task can be executed by a senior and a renowned teacher can do this. Understanding the implications, intricacies of various judicial development, judicial decisions, constitutional mandates, and above all, the concept of parliamentary democracy. When we speak about the doctrine of basic structure, we always directly go to the Keshavananda Bharati case, 1973. Much earlier to that also there was a discussion on the basic structure. But the real
and the fervor of the basic structure was felt 1973 in Keshavananda Bharati case. That apart the various interpretations given by the Supreme Court in Keshavananda Bharati, Sadri Prasad case, Sajjan Singh case, a series of cases upholding the constitutional amendment, nullifying the constitutional amendment, bringing the constitutional clause, different amendment clauses, amending clauses, again upholding and nullifying. See, these are all the conflict of legislature and judiciary in the parliamentary system of government. We are living in a parliamentary system of government wherein the highest democratic institution in this country is parliament. Because the constitution is given by ourselves. We the people of India given the constitution to ourselves and nobody has given. When the people are representing the highest democratic institution like parliament, parliamentary decisions or parliamentary legislations needs to be respected. Because every legislation made by the parliament is reflection of the true spirit and true intention of the people. I think you must have already read the Savini's theory of law. What Savini says in his theory of law, the true spirit of the people is the foundation of law. The true intention of the people is the foundation of law. And law reflects the spirit of the people. Law emanates from the spirit of the people. Law emerges from the spirit of the people. And that is the theory of Savini's theory of law. When we move on to the basic structure theory, I think the basic structure theory encompasses everything. Whatever is left out in the original constitution is encapsulated and it covers everything in the basic structure theory. But in the garb of covering the basic various things in the basic structure theory, one should be very careful. 100%. One should be very 100%. Sensitive. 100%. What are all requirements for the people? It is ultimately the people's intention to be respected. We have been seeing that many legislations are being made even without taking the intention of the people. Even without taking the recognition of the people. What is the people's intention? By making a law and then giving the legislation to the people and then find out the opinion of the people is not the true democracy. It is not the true parliamentary system of government what we have. The true parliamentary democracy of the Indian Constitution is that the true spirit of the people should be respected before making a legislation. But time and again, what is not found in the Constitution is going to be recognized by judiciary. In the process of recognizing the judiciary, there could be an infringement of the intention of the people. There could be the infringement of the rights of the people. Professor Uke was very beautifully providing discourse on the power of the president and the power of the governor, the recent development which took place in Tamil Nadu. It is true that in the Constitution there is no specific particular provision, particular time limit for giving the consent for the bills. It is true. The makers of the Indian Constitution, Dr. B.R. Ambedkar, led by Dr. B.R. Ambedkar, left it deliberately. It was not left without any deliberation. Deliberately, the time limit was left in the draft constitution, not to give time. The only provision of the constitution is that when a bill is submitted after validly passed by both the houses, when it is submitted to the governor or president, he shall give assent. If he requires any clarification, or if he finds that the bill which is passed by both the houses of parliament or legislature found to be not reasonable, not projecting a social justice, he can keep it. He can send it for reconsideration. Even after reconsideration or with amendment or without amendment, if it is sent back to the president, he shall give the consent. Now the question is, even after reconsideration and send it back the bill, if the president and the governor fails to give the consent, what is the remedy available in the constitution? What is the remedy available? Is there any remedy? There is no remedy at all. Then we have to look into the role of the judiciary. That is exactly where we find today that the judgment of the Supreme Court fixing the limitation of 1 month and 3 months for governor and the president respectively. Suppose a bill is passed with some provisions which affects the people's interest, which affects the rights of the people. It could be ordinary rights or it could be constitutional rights. After the cessation of 3 months, it is mandatory to give consent and it becomes a law. Whether that law will be respected by the people, if it goes to the intention of the people, goes against the spirit of the people, goes against the rights of the people. See, these are all the things which needs to be discussed, needs to be deliberated. Now we have decision given by the Supreme Court on the powers of the governor and the president. Now the debate starts. Whether it is a subversion of the constitutional power, whether it is a subversion of the judicial power or subversion of the judicial power, or is there any excess of judicial power? Shall we call it as a judicial activism or judicial over-activism? As a teachers of law, as a students of law, as a legal fraternity, we need to ponder over this. It is not that everything what is said and what is given by parliament needs to be accepted and what is given by the judiciary needs to be accepted. Though under Article 141 of the Indian Constitution, it is binding on all the lower courts. But what happens if such a legislation such a bill is assented by the governor or the president after 3 months or 1 month, mandatorily as directed by the court, if it contains a provision which is derogatory to the interest of the people, what is to be done? Then what is the role of a judge? What is the role of a governor? And what is the role of a president? This president is only a nominal head in a parliamentary democracy. I still remember when K. Narayan, when he was a president of this country, one of the state's governors sent a report to him saying that there is a constitutional machinery has struck down. Constitutional machinery has struck down. There is a failure of constitutional machinery, and therefore I am recommending for the imposing of presidential rule under Article 256. K. Narayan did not accept it. K. Narayan did not accept it. Even though the bill was passed, even though that recommendation was made by the governor, which was placed before the cabinet of central government, and the cabinet approved it and sent to the president for assent, the assent was not given. Former President of India, K. Narayan said, I have my own power. I have a constitutional power. If any recommendation given by any governor for the imposing of presidential rule, if it is found to be nullified, if it is found to be nullified, if it is found to be violation of the social justice, derogatory to the social justice, I am not going to consent it. The bill was rejected and sent it back to the central government. See, we need to look into the constitutional power. It is not just the president and the governor are left without any powers. They too have the powers under the parliamentary system of government. But once they are found to be exceeded the power, not exercising the power or exceeding the power which is not provided to them, then only the other authorities should interfere. Every interference of one organ with the other organ is a subversion of constitutional morality. It's a subversion of constitutional morality. And of course, the basic structure theory, though it encompasses various other rights, various other concepts, even today the basic structure theory, when it is being interpreted by the judiciary, keeps on including so many concepts. There is no end for it. If it is only for the interest of people, if it is only found that it is based upon the true spirit of the people, it is acceptable, it is honored. So therefore, the basic structure theory and the amendment provisions, and of course, Parliament being the highest democratic institution, has been conferred with constituent power. It is true. It is true that it is empowered with constituent power. It is not an ordinary power. When the constituent power is hampered by the other institution, and where that constituent power is reflected by the whole gamut of the members or the whole population of this country, how far in a parliamentary system of government, demolishing such kind of decision taken in the parliament, highest democratic institution, by a single judge of the judiciary, can be acceptable. Can be acceptable. So therefore, there is a debate going on still that there is a conflict between the legislature and judiciary. The conflict arises because of the principal reason. The fundamental reason is that the parliamentary system of government, there is a fusion of power. There is a fusion of power between the legislature and the executive. The same legislator who legislates the law, sitting in the parliament, he will execute the same law here. And whatever the law he wants, he desires, he requires, he will place it before the parliament in the form of bill and get it passed. If he is having a majority in the parliament or legislature. So therefore, we do not have a strict compartmentalization of separation of power, what we find in the American Constitution. And of course, the reference of Schedule 9, 9th Schedule, Ayer Coelho case is the best example. Whatever may be the nature of amendments, even if it is put into the 9th Schedule, it is not immune from judicial review. Just like Article 368 empowers the Parliament a constant power to amend any part of the Constitution subject to this basic structure theory, so also a judicial supremacy is also provided under Article 13. No law can be made by any legislature in this country, including the Parliament, affecting the fundamental rights, in derogation of the fundamental rights. Can we call it as a supremacy of the judiciary? Article 13 is the supremacy of the judiciary. Can we call Article 368 as the supremacy of the legislature? I think ultimately the answer lies with only the Constitution. Our Indian Constitution is the supreme, neither the legislature nor the judiciary supreme. Every time we have been seeing, even in respect of the reservation policy, if the legislature makes a legislation on reservation policy, the judiciary will nullify it. Once the judiciary nullifies it, the legislature will bring an amendment to it. And once the amendment is made, again the amendment will be nullified by the judiciary. What is this? This is not a question of supremacy of any one organ of the government. They are all subsidiary organs of the Constitution of India. But in the interpretation of the provisions, in the interpretation of the provisions of any legislation, or in the making of any legislation, in the garb of making any legislations, neither the legislature nor the judiciary can subvert the constitutional values. And that is the fundamental constitutional mandate for legislature as well as judiciary. And of course, we are more protected after the doctrine of basic structure was evolved by the judiciary. We are more protected. So many rights were brought within the ambit of basic structure. But at the same time, we should also honor the parliamentary democracy also. The parliament is consisting of people's intentions. It is the people intention, it is the people's spirit in the parliament which makes the legislations also needs to be respected. Subject to the derogation, subject to the infringement, and subject to the violation of the established rights. Professor Uke was telling very beautifully the formal amendment and informal amendment. I think whatever the judiciary is interpreting all the provisions today, where there is a gap in the constitution, where there is a gap in the law, they are all informal amendments. Informal amendments being made by the judiciary to the constitution. But in the garb of making an informal amendment, can you take away or can you distort the specific or the stipulated power of certain constitutional machineries? Certainly it is not. Today, for many powers exercised in this country, there are no legislations. There are no laws. For example, as Professor Uke said, in the appointment of Chief Justice of India, where is the legislation? It is only the convention. We have been following the convention borrowed from England. The senior most judge of the Supreme Court shall be the Chief Justice of India. The leader of the party who enjoys the majority in the parliament or on the floor of the house shall be called for forming the government. Where is the law for it? There is no law for it. There is no constitutional law or any law for that. It is only the convention. So therefore, we need to respect even the conventions. We need to respect even the existing legislations. At the same time, we need to respect the parliamentary democracy also. Parliamentary democracy. And I hope that today's discourse on this amendment, constitutional amendment and doctrine of basic structure, has given a very important inputs for the students of law, for the teachers of law, and the entire legal fraternity to look back and to find out the efficacies, the intricacies, and the reliability of to what extent the ultimate objective of the Constitution is ensured through the interpretations, through amendments, and through basic structure theory. Thank you so much.
Thank you, sir. I now request Ms. Deeksha Patil, student KSLU's Law School, to please propose the vote of thanks.
Good afternoon, everyone. I, Diksha Patil, student KSLU's Law School, Hubli. It gives me an immense pleasure to propose the vote of thanks. I express my heartfelt gratitude to Professor Dr. Dilip Uke, Honorable Vice Chancellor, Maharashtra National Law University, Mumbai, for being a part of our day and addressing us with his kind words. Indeed, everyone's mind has been filled with thought-provoking notions. I thank you, sir. I also thank a guest of honor, Shri Anurag Katarki, barrister and advocate, Mumbai, for his distinguished presence. I thank you, sir. I express my gratitude to Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, Hubli, for your valuable insights and enthusiastic address. I thank you, sir. I also express my hearty gratitude to Professor Dr. Ratna R. Barangaudar, Dean, Registrar Evaluation, Karnataka State Law University, and Director, KSLU Law School, Hubli, for your constant support and being a pillar of strength. I thank you, ma'am. I also thank all the dignitaries, invitees, media personnel, teaching and non-teaching staff, and students without whom the success of this event would not have been possible. I once again thank each and everyone. Thank you.